We've got some major updates in the ongoing legal fight against the ATF's pistol brace rule. Recently, there's been a big development in one of the most significant cases, and it could have a major impact on others. The Department of Justice, under the Trump administration, has officially agreed to drop its appeal in the Fifth Circuit regarding the Mock versus Garland case. This case had already resulted in a nationwide vacatur of the pistol brace rule, and by dropping the appeal, that decision from the lower court will now stand. For context, the pistol brace rule classifies most braced pistols as short-barreled rifles, which subjects them to the same strict regulations under the National Firearms Act. This rule faced multiple legal challenges across the country, and the Mock case in the Fifth Circuit was one of the most important. It not only secured a nationwide halt to the rule, but also led to several preliminary injunctions protecting various organizations, companies, and their members. The Biden administration initially appealed the decision in Mock, but after the Trump DOJ took over, they made the choice to withdraw that appeal entirely. Now this move is creating a ripple effect. It's already influencing another major pistol brace case, this time in the Eighth Circuit. That case, involving the Firearms Regulatory Accountability Coalition and SB Tactical, also challenges the ATF's pistol brace rule. In light of the Mock outcome, attorneys in the Firearms Regulatory Accountability Coalition lawsuit have notified the court that they are considering settling as well. The notice sent by the Trump-era Department of Justice to the Fifth Circuit stated that, under Federal Rule of Appellate Procedure 42(b)(1), both parties agreed to dismiss the appeal. Each side will bear its own legal costs, but the plaintiffs still retain the right to request attorney's fees in the district court, including fees related to the appeal. This confirms that the government has officially dropped its appeal in the Fifth Circuit. That court has already acknowledged the dismissal and sent the case back to Judge O'Connor. This means Judge O'Connor's previous nationwide order vacating the ATF's pistol brace rule will now likely go into full effect. At this point, it appears the ATF is conceding that the rule is effectively gone. As mentioned earlier, there were several other lawsuits tied to this issue. In addition to the Mock case, there were cases filed by Gun Owners of America, the National Rifle Association, and the Brito case, all of which were also under the Fifth Circuit's jurisdiction. Outside of the Fifth Circuit, there was the Firearms Regulatory Accountability Coalition lawsuit in the Eighth Circuit, filed by the Firearms Regulatory Accountability Coalition in partnership with SB Tactical and 25 states. Now, in the Firearms Regulatory Accountability Coalition case, both sides have submitted a joint notice to the court referencing the outcome in Mock versus Garland. They explain that the Fifth Circuit dismissed the appeal in Mock on July 25th and that they are now working toward resolving the FRAC lawsuit without further litigation. They have asked the court to keep the case on hold for another 30 days while they continue negotiations with the ATF. This is significant because following the dismissal in Mock, we expected these related cases to move forward. Instead, it seems the parties are choosing to negotiate settlements, which could mean similar outcomes, possibly ending these cases without the need for full trials or appeals. However, there is a larger consideration here. By agreeing to settle or dismiss these cases now, gun rights advocates achieve an immediate victory, the end of the pistol brace rule. But there's also a trade-off. Settling means potentially missing the chance to secure broader, precedent-setting rulings in multiple courts, including at the appellate level. It's worth noting that the Mock case ruling was limited in scope. Judge O'Connor's decision focused on the Administrative Procedure Act and the logical outgrowth test, not on the Second Amendment itself. That means the case did not produce a ruling on whether the pistol brace rule violates constitutional protections. Settling now avoids further risk, but it also leaves some important legal questions unresolved. Now, if a future administration attempts to introduce another pistol brace rule, similar to the one recently struck down, they could essentially try to reintroduce the exact same regulation. The difference is, they would need to make sure it follows the proper procedures outlined in the Administrative Procedure Act, or APA. Judge O'Connor didn't strike down the pistol brace rule because it directly violated the Second Amendment. Instead, his decision focused on the fact that the ATF failed to follow the APA's procedural requirements, specifically the logical outgrowth test. Here's what that means. When the ATF first proposed the rule, they included a worksheet. Worksheet 4999, which used a points-based system. The system assigned points to certain features of a firearm, and if the total exceeded a certain number, that firearm would be classified as a short-barreled rifle. However, in the final version of the rule, the ATF completely removed that worksheet. According to Judge O'Connor, that was a major problem. Since the worksheet was part of the original proposed rule but didn't appear in the final rule, the ATF essentially changed the rules mid-process without giving the public a fair chance to comment on those changes. That's what violated the logical outgrowth requirement. So, in the future, another administration could try to bring back a similar pistol brace rule, but as long as they keep the proposed rule and the final rule consistent, and follow the APA's guidelines, they could avoid this procedural issue altogether. For now, though, we're seeing a different trend. The Trump Department of Justice and the plaintiffs in several of these pistol brace lawsuits have decided to either settle their cases or withdraw their appeals. And it appears the same approach is about to happen in the SB tactical case involving 25 states, which is currently under the jurisdiction of the Eighth Circuit. In short, many of these pistol brace cases seem headed toward resolution, with agreements between the parties and the ATF. If that continues, it looks likely that the pistol brace rule will end up being struck down nationwide. At the moment, we're still waiting for the final rulings in some of these cases. Once those decisions are handed down, we'll have a clearer picture of how this all plays out. As soon as new information comes in, I'll keep you updated.